Good morning, everyone. I welcome you all to the workshop of ICSI IIT on the topic Insights of Real Estate Sector under IBC. Today, we have with us Mr. Manish Paliwal and Mr. Anil Goel as faculties. The first session will be taken by Mr. Manish Paliwal. Let me provide you a brief introduction of Mr. Manish Paliwal. Mr. Manish Paliwal is an advocate on record in the Supreme Court of India, a registered insolvency professional, and a fellow of CIARB. He has rich experience in dispute resolution, including mediation, arbitration, and litigation. Mr. Manish Paliwal has a lot of experience representing clients in both contentious and non-contentious cases in courts and tribunals across India, including Supreme Court of India, the Delhi High Court, the National Company Law Tribunal, and the National Company Law Appellate Tribunal. He has a lot of published judgments on a wide range of topics. Since 2006, he has worked in the areas of arbitration, corporate law, bankruptcy, and insolvency, banking, real estate, intellectual property, cyber law, administrative law, land acquisition, government contracts, consumer and competition law, etc. Over to you, Mr. Manish Paliwal.
Thank you very much, and thanks all. I like this session to be a little bit interactive because 3 hours is too much to be in a monologue, like one person speaks and others participate. That will be easier for me as well. And I'm thankful to some of the people who have switched on their cameras so I can know and interact, that at least I'm talking to someone. Sometimes what happens in these sessions is that the screen is completely blank. So thank you, Sushil ji and Ranjan ji and Ajay Kumar ji, and Saurabh ji. Am I audible to all of you?
Yes, sir.
Yes, absolutely.
Yes, sir. And all are requested to please switch on their cameras.
Some of them are having lunch, dinner, or etc. Okay, so the topic for the day is basically the Consumer Protection Act and the RERA and vis-a-vis its implication on the IBC. The second part is much related to the IBC proceedings. The first part is bit academic, which is more related to the Consumer Protection Act. But there is a reason why this topic perhaps has been chosen by the institute, because it has the implication on the insolvency proceedings. In two ways, the implications are there. First, when any real estate company goes into insolvency, it has a lot of cases which were pending before the admission in the CIRP. So those cases get stayed, but at least those claims are filed. And even in that segment, there are people who have got their degrees fructified, like where their damages have been awarded or they are pending in appeals, and there are some kind of judgment in the favor of the consumer. And at the same time, in case of RERA, also there are people who are approaching instead of Consumer Act, the RERA as well. And in RERA also, they are getting the orders against the builders and the real estate companies to some extent, sometimes refund, sometimes a payment of the damages and etc. and etc. So there is an interplay of these acts in between themselves with the IBC pre and post CIRP. And sometimes during the CIRP as well. So pre-CIRP in the sense that there are orders, and post-CIRP, like how in the resolution plan these issues are dealt with and how the people should take care of the issues which arises from these two legislations. The RERA and the Consumer Protection Act basically falls into category of the legislations which are meant to protect the consumers. These are consumer-centric legislations per se. These are the branch of, like, you can divide the legislations in various kinds of the theme in which they go. So IBC is primarily resolve the companies who are not performing well or when there is a default and etc. and etc. IBC per se is not a consumer-centric legislation. But unlike the IBC, the two are consumer centric. So the first and the foremost things happen with these things, like these are the remedies which exist simultaneously. Like the first thing which happens in a Consumer Protection Act, that is an additional remedy. So what is the meaning by the additional remedies? So if somebody has gone to a consumer forum, he can also file a suit. He can also go to a RERA. And if he is not satisfied with all those proceedings, he can come back and even file an IBC. So this is something peculiar to the consumer-centric legislations, where the remedies which are provided to the consumers are in addition to what already other existing remedies are. They are not subrogated or suspended by virtue of the other remedies. This is one of the core theme of the legislation. Second, in all these legislations, the legislature has clearly decided that the bargaining power is not equal. So the underlying theme of these legislations are that when a person is dealing with a company which is in construction sector, there is an unequal bargaining power between the builder and the person who is buying a flat, unit, etc., anything, because of which he needs protection. Secondly, this legislature has, over the period of time, has experienced that these people get cheated frequently. So, from the beginning to end, a central theme runs through both these legislation is to protect these people. Another thing which the legislature has tried to do with these things is to enforce some kind of discipline in the person who is providing the services or the goods, and in this case, the building flats and the owners and etc. So there are certain timelines which are inbuilt in the RERA. There are certain escrow agreement and everything. All of you are like seasoned professionals, so you know already how these things work. And in the Consumer Protection Act, the court has been given the power to even modify the contracts which they feel unfair. That is another aspect which touches lightly on the issue of the competition. So another consumer-centric legislation in the same category as RERA and the Consumer Protection is the Competition Act. Normally, if a practice is anti-competitive, it will go into the domain of the Competition Act. But with this 2019 legislation, the activities which are related to the consumer or unfair trade practices have been brought within the purview of the Consumer Protection Act. So power has been enhanced. As a practitioner, one of the things which we have, we know as a matter of fact that prior to 2020, somewhere in 2020, when this new Consumer Act was notified, there was an old Consumer Act, Consumer Protection Act. And that consumer protection was not as effective as it should have been. So there was a lot of delays, and the pecuniary jurisdiction was very small for the Consumer Act to decide this builder-buyer agreement dispute, because there was few lakhs limit. That limit has been significantly enhanced in 2019 Act. So those are the core themes which will run through. I prepared a presentation, but I would like to I will begin with the slides, but ultimately I will shift to the Bear Act, because that is something which, as a professional, we should know, and every question is answered there, or if it is not answered, it's tried to be answered by the court by taking reference of those very simple provisions which are there in the Act itself. So I'm just sharing the presentation, just a second. share the screen. So, yeah, all of you are welcome. This is just my address. All of you are welcome to my office. Have discussion on any of these issues pre and post this presentation. So the first topic is overview of the real estate sector in India. The real estate sector is global. It not only comprises of the housing, real estate, hospitality, and commercials. It has its own unique problems, and it is one of the most growing sector as such. After like the pandemic is over, again it is picking up. So many of the insolvencies have turned upside down and again back. So what are the peculiar factors? High dependency on the physical workforce. In fact, I would like to modify it like a high dependency upon the cash flows. Like most of the transactions which were happening in this sector was on the cash. So resolution professionals find it very difficult to trace those monies in the accounts and the claims. The mismatch of the claims and the account books of the builders is one of the major problems. Surge in the cost of the construction material over the period of the time. Most of the CIRP proceedings are divided into two categories. One, where the promoter or the builder has siphoned off the money, or the project became unviable because of the external or the working capital issues. Those are the two primary reasons for the failure of these things. The third major challenge is the land acquisition, either from the private parties or by the government or etc. And are these the problems which are being faced by this sector? And role of the IBC. So IBC has turned this sector, which was in the American parlance, which we can say that it was a kind of Wild West. The people were trying, people were sold, the projects were sold, which did not exist on the paper, on the ground, and huge investments were gathered from the market, and there was a high risk-taking appetite among the businessmen who were dealing in these sectors. So it is not uncommon to come across a project where the land belongs to one person or an authority. The license is taken by the another person. Second, then both of them collaborate together, or a third person comes in and collaborate together and build the entire society. The person who has built the society doesn't sell it, he incorporates another company which ultimately sells it to the consumer. And after it's being sold to the consumer, the flats are allotted. And in the flats, like since the building bylaws only provided that one can have the units, so it's like arbitrary. They can increase the number of unit, reduce the number of unit, and since there is no registration of the units, so the units can be frequently changed, altered in their position, as well as one unit is allocated to the multiple members. Sometimes the things are sold even in the air, like when they did not exist or when they are not supposed to exist as per the approved building plan. So because of all these issues, there were defaults, and defaults, the earlier threshold was really low. Anybody, 1 lakh default was nothing, and all the people started approaching. So thereafter, in order to bring discipline in the industry, the legislature thought it appropriate to bring in amendment under the section 7, where at least 100 people or the 10%, whatever is first met, are allowed to file insolvency proceedings against the real estate companies. So, because of the amendment, there are two types of cases. Primarily, we see in the IBC, pre-amendment and the post-amendment. So pre-amendment, many of the companies got admitted to IBC very easily. Post amendment, it is getting difficult for the home buyers to invoke this remedy because a good number of time they do not know the other people who are there, whom they can actually approach and find out that how to meet the 10% criteria or 100%. Even the criteria of 10% is bit dicey because 10% of the number of units sold, then how many are the number of the units, sometimes that those numbers get varied. And many of the builders have not uploaded their data properly on the website of the RERA. So it's not easy to find out for the people that how and what is happening in these things. One of the major challenges in invoking IBC and preference over the Consumer Protection Act and the RERA is one thing, because in IBC, the threshold to invoke the IBC has raised significantly, because of which it became financially and economically not viable for these creditors to invoke the IBC to some extent. So some of the people still choose the Consumer Protection Act because there the court has the power to even vary the contract, which is not there in IBC. Just a second. I need to take a call. I apologize. Sorry. So, one, it became financially unviable, and dusra, it's easier for the people to approach the Consumer Protection Act for the simple reason that they can file a complaint, they can pursue it themselves, and the court has the power, it's closer to their jurisdiction. So, one of the primary differences among the others in the IBC and the consumer protection is the choice of the jurisdiction. In all the consumer-centric laws, the jurisdiction of the court has been given to the place where the consumer resides. Unlike in the IBC, where the jurisdiction is at the place where the company is registered. And therefore, like there is a tendency among the people to invoke the consumer protection laws over the IBC. So this is also one of the reasons the people are still choosing or were choosing the Consumer Protection Act. And this approach of consumer protection has been where the jurisdiction can be taken at the place of the consumer has been fortified under the new act, which is 2019 act. When we go, we will see it in a detailed thing. So role of the consumer protection and resolving the, so there are like slides and slides, but I would close these slides and I'll directly share the actual act, which is relevant here. Just a second. Okay. So, could you see my screen? Consumer Protection Act.
Yes.
Thank you. Sir. So this is I have taken this copy from the gadget itself, and it's really some of the people have experience in reading the gadget, but I'll still like to read it from the gadget for the reason that this is one of the most basic thing, and it gives various insights how a statue is supposed to be read, because nowadays the people have started reading everything from the Google, but still going to the basics makes a lot of sense. So this is an act which has been enacted in 2019. So 2019 is the 9th August 2019, but it actually come into force in 2020, somewhere in the April. The purpose of this act is to provide protection to the interest of the consumers. Just a second. The act to provide for protection for the interest of the consumer, for the said purpose established authorities for timely and effective administration and settlement of the consumer disputes and for the matters connected therewith. This is called preamble, and the preamble is sometimes encompasses a thing which are very important for the entire thing. So what it says, first, protection of the consumer, definitely there. There is an authority who has been made a custodian. So there is another regulator who has been notified in this act, whose primary job is to protect the interests of the consumers. So lately we are seeing that in many of these legislations, these regulators are coming up. So they are making the laws like IBC, Competition Act, Electricity Act, Telecom Act. So even in Consumer Protection Act, now there is some kind of a government body who is tasked to protect the interest of the consumers. So this has also joined the long line of the other acts. Then the first section is not that much of relevant. The second section is relevant. The second section is a definition section. It deals with many of those things which are crucial in nature. The first is the advertisement. Earlier, what used to happen is that when any real estate project was getting advertised, the people had scant regard to the law. Even the correct details of the person who is coming out of the project was not given. Misleading advertisements were there. There were endorsement of the project by the celebrities who had no knowledge of the idea that how genuine is the project and what are the problems, whether the land belongs to them or not, and etc. So in order to protect the consumer from many of those malpractices, there has been a specific definition of advertisement has been incorporated to make sure that the person who makes the statement or advertises the people about the product made responsible for it. This is a unique feature of this act. So first is advertisement. Advertisement means any audio, visual representation, etc. That's something. Then the laboratory testing is also provided, not very relevant for the purpose of the builders. The branch office definition is provided. Now the next important definition in section 2 is a complaint. So unlike IBC, where the right to file section 7 has been given only to the creditors and only when they meet the threshold, in Consumer Protection Act, the complaint can be filed by the consumer and other persons. So who are those other persons? First, consumer. Second, voluntary consumer association registered under any law. Like in labor laws, the union can file. Here also the association can file, and there are various consumer organizations which has come up who are doing these things. The central government, state government, central authority, one or more consumers where there are numerous consumers having the same interest. So there is a provision of class action, but there is no threshold. In case of death of a consumer, his legal heirs, legal representatives. In case of consumer being minor, his parents and the legal guardians. So these are the people who are entitled to file complaint under the Consumer Protection Act. So for what purpose a complaint could be filed? This is also very unique. In IBC, it's simple, only default. Here it is what? Means any allegation in writing made by a complainant for obtaining any relief provided under this act. What are those reliefs? The first is unfair contract or unfair trade practices or restrictive trade practices has been adopted by any trader or service provider. So the scope is very large. It's the most comprehensive thing encompassing everything under the sun for which a complaint can be filed under the Consumer Protection Act. The goods bought by him or agreed to be bought by him suffers from any or one of the more defects. So Consumer Protection Act can go even after the resolution plan and even after the completion of the project. The services hired or availed or agreed to be hired or availed of by him suffers from any deficiency. A trader or a service provider, as the case may be, has charged for the goods or for the services mentioned in the complaint a price in excess of the price fixed by any unfixed by or under any law for the time being in the force. These sections are going to create many new issues, and in fact it has changed the dynamics of the industry, because earlier there was like built up area and everything. Now the concept of the carpet area has come in the RERA and as well as in the Consumer Protection Act. So what is being built up as a top up does matter. Then displayed on the goods or any packages containing such good, display of the price list exhibited by him or by or under any law for the time being in force, agreed between the parties, so escalation and everything. The goods were which are hazardous to life and safety when used are being offered for sale to the public, like bad quality of the construction, the contravention of the standard rating safety of such goods, where the trader knows that the goods so offered are unsafe to the public, the services which are hazardous, a claim of the product liability and etc. So everything under the sun, whether it relates to only like only one thing or not, it's not limited. It is like whether the quality of the construction, fitting, post-completion services, overselling, anything, misrepresentation, everything can be covered under the Consumer Protection Act, which cannot be covered under the IBC. And this is also one of the reasons some people choose the Consumer Protection Act. Now, who means a consumer? So the definition of the consumer is also matters. Like consumer is not only the person who buys the good. The consumer is also person for whom the goods have been bought. Then it need not be that the entire consideration has been paid. Even a person who has paid part consideration is a consumer. So there are two parts of the definition. The first part relates to the goods and the second part relates to the services. So I'll read only one part of it for the sake of clarity. Buys any goods for a consideration which has been paid or promised, or partly paid or partly promised, or under any system of deferred payments, and includes any user of such goods other than the person who buys such goods for consideration paid or promised, or partly paid or partly promised, or under any system of the deferred payment. So it doesn't matter whether the payment has been made or not. It is suffice to launch a proceeding if it is promised to be made. And the person who is paying need not file it. The person who is receiving the benefit can also file it. Those are the unique proposition in the Consumer Protection Act. Then the consumer protection has a one caveat. The caveat is that any person who avails any goods or services for the commercial purposes cannot take benefit of the Consumer Protection Act. So explanation, so the end line of both the section provides, but does not include a person who avails such services for any commercial purposes. So what is that commercial purposes is been defined in the explanation. Explanation says the expression commercial purposes does not include use by a person of the goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. Then B, the expression buys any goods and hires and avails any services includes offline and online transaction. This is not that much of relevant. So there were multiple case laws where one of the plea was taken by the building companies to deny the benefit to the consumers, to say that a person has bought like 4 units and 5 units and therefore he is not an allottee, or he should not get the benefit of the Consumer Protection Act. In all those cases, not exactly all, but in most of those cases, the NCDRC as well as the Supreme Court have upheld that unlike a person himself is in the business of the property dealing where his stock in trade are the flats itself, merely because he bought 1 or 2 or maybe 3 units for something cannot be termed as a person who is doing the business or the commercial purposes. And those people were given the benefit of the Consumer Protection Act in the form of some kind of damages and etc. So, unless a person who has taken a large inventory, he is regarded as a consumer. But if a person has taken a large inventory, he can still be he will still be a financial creditor under the IBC, but he cannot take advantage of the provisions of the Consumer Protection Act. So the consumer rights are very important. The rights were not defined under the previous Consumer Protection Act. What are the rights? The right to be protected against the marketing of the goods, products, or services which are hazardous to the life and property. 1. 2. The right to be informed about the quality, quantity, potency, purity, and standard price of the goods, etc. So that is a right. The right to be assured whether possible access to a variety of the goods and products and services at a competitive prices. The right to be heard and to be assured that consumers' interest will receive due consideration at appropriate forum. The right to seek redressals against unfair trade practices and the restrictive trade practices or unscrupulous exploitation of the consumer, and right to consumer awareness. These rights have significant implications on the overall jurisprudence which is being developed. Because of these rights, the court can strike down any condition which they find it highly in the favor of, built in the favor of the construction company. So these are the rights. It were not available in the last legislation before 2019. Defects. The definition of the defects deficiency has been significantly widened to mean everything. So I'll just read the defect. Defect means any fault, imperfection, shortcoming in the quality, quantity, potency, purity, standards required, and etc. The deficiency, design, direct selling, and other definitions are not related, not relevant for our discussion because our discussion is centered around only on the real estate sector. Then one of the key things in this Consumer Protection Act that the e-commerce has been added, which were not there before in the last act. So the e-commerce means buying or selling of the goods or services, including digital products over the digital or electronic network. Some of the companies have started, why this is relevant is some of the companies have started selling their offerings through internet. So all the provisions of the Consumer Protection Act will automatically be applicable to them. Then another important definition is endorsement. Endorsement directly relates to advertisement, but it is slightly more than that. What is endorsement? Endorsement in relation to an advertisement means any message, verbal statement, demonstration, depiction of the name, signature, likeness, and other identifiable personal characteristics of an individual, depiction of the name or the seal of any institution or organization, which makes the consumer to believe that it reflects the opinion, finding, or experience of the person making such endorsement. This is extremely relevant for the reason that when advertisement for a project get published in the newspaper or on internet, there is a tendency among the building companies to build the credibility to show certain logos of various banks and the institutions which is supporting this kind of the project. Two, there has been cases in the past where the celebrities have endorsed those projects to say that they reflected in the advertisement. The people believed in the goodwill of these people as well as the institution and bought the property. Once they have bought the property and the cases were filed against the builder, and when these people were implicated, a defense was taken by these institutions and the people that we are not actors in the project. Say most of the banks started saying that we have only provided to the loan. That's it. Our core borrower is the person who has purchased the flat. Therefore, my logo appearing in the newspaper does not make a difference and make me liable. One. Similarly, some of the celebrities have taken that this was a particular advertisement. We are only the actors. We have never scrutinized and done due diligence of the company who has come out with an advertisement. And therefore, we should not be made liable for the actions or the omissions or the wrongdoing of the companies. That kind of defense is taken away in the Consumer Protection Act. So, what has been done is that now a person who is endorsing a certain product must be cautious that his image should not be utilized without proper due diligence. So there is a responsibility on the part of the person who is endorsing the project to do the due diligence beforehand before saying that this product is good. It applies to all kinds of advertisement, but it is also relevant for the real estate sector. So there is a definition of establishment, express warranty, goods, harm, injury, manufacturer. These definitions are not relevant. The another definition which is relevant in for the today's discussion is mediator. So there is a profession which is being carved out, or which is emerging in all the legislations of the new age legislations to say is that the role of the alternative dispute resolution ADR is increasing day by day in all the legislations. Probably it is going to come up in the IBC as well. It has come in the commercial court already, and it has come into the Consumer Protection Act. So as an insolvency professional, as a chartered accountant, there is another stream of profession which is being developed as a mediator and arbitrator. So a certain extent, a right has been given to the people to explore a forum other than the courts, which is ADR, either through mediation or through an arbitration. So mediator means a mediator referred under section 75. Then 28 is relevant. Misleading advertisement. It relates to the earlier theme of the Consumer Protection Act. In relates to any product or service means advertisement falsely describes such products and services, gives a false guarantee or is likely to mislead the consumer as to the nature, substance, quality, quantity of such product or services, conveys an express or implied representation which, if made by the manufacturer or seller or service provider thereof, would constitute an unfair trade practices, deliberately concealed important information. That is the one of the most significant addition to this definition. So merely advertising is not sufficient. Any material information which is relevant, and if it has been concealed, that would mean misleading advertisement. It has become something like the court proceedings where under the verification you say that I have disclosed everything and nothing material has been concealed by me. So if somebody is saying that this is an actual product and like actual construction site going on, but he doesn't disclose that the land is under the dispute or there is some significant impediment, that may tantamount to misleading advertisement in this section. So the scope is extremely wide, and the protection given to the Consumer Protection Act to the every person is more than any other act. Then definition of National Commission, obviously it is there. Notification, person includes everybody. Like even if like a cooperative society, HUF, the property has been purchased by the HUF, artificial jurisdiction person, except the association of the person registered under the society, corporation companies, everything is there. So the product liability action, product manufacturer, these definitions are strictly related to the goods. Product seller, product seller can be related to everything, like it includes everything. So, but the definition is almost obvious. So I'm not devoting much time on it. Then the definition of regulator. Regulator means a body or authority established under any of law for the time being in the force. And the next important definition is restrictive trade practices. Restrictive trade practices means a trade practice which tends to bring about manipulation of the price or its condition of delivery, or to affect the flows of the supplies in the market relating to the goods or services in such a manner as to impose on the consumer unjustified cost, and the restrictions and shall include delays beyond the period agreed to be trader in supply of such goods or in providing the services which has led or is likely to lead rise in the price. So that's one of the very significant additions, and delay is almost everywhere in all the projects. Any trade practice which requires a consumer to buy, hire, or avail of any goods, or as the case may be services, as a condition precedents for the buying of, hiring, or availing the services or goods. That's something which can be depend upon case to case, but the first part is very crucial. Services means almost everything, including the maintenance and etc. Spurious goods, state commission, trader, unfair contract definition is again relevant, because under this clause, most of the contracts get modified under the Consumer Protection Act. So unfair contract means a contract between a manufacturer or a trader or a service provider on the one hand and a consumer on the other hand, having such terms which cause significant change in the right of such consumer, including the following, namely the first, requiring manifestly excessive security deposit to be given by the consumer for the performance of the contractual obligations. Imposing any penalty on the consumer for the breach of contract thereof, which is wholly disproportionate to the loss occurred due to such breach to the other party to the contract. So all those damages clauses can be scrutinized under the Consumer Protection Act by the authority. Refusing to accept early repayment of the debts on the payment of the applicable penalty. Entitling a party to a contract to terminate such contract unilaterally without reasonable clause. All these vices are present in the present builder-buyer agreements. Permitting or has the effect of permitting one party to assign the contract to the detriment of the other party who is a consumer without his consent. That is also there. Imposing on the consumer any unreasonable charges, obligations, or conditions which put such consumer to disadvantage. If you read any of the old contract by any of the leading builders, then you will find all these things present in those contracts in various shapes and the form. Except the first one, like this excessive deposit clause might not get triggered, but all other things are present in all builder-buyer agreements, if you go collectively. So these are now termed as unfair contracts. And because these are unfair contract, a consumer gets the right to approach the consumer forum. So the rights available in this act is the widest possible terms, and this has been couched. Now, the next important definition is unfair trade practices. Means a trade practice which for the purpose of promoting sale, use or supply of any goods for the provision of the service adopts any unfair method or unfair or deceptive practices, including the following. The word including is very important because when you use this word, then there may be things which are not listed below and can be included in it. So let's see the list and then find out what could be included is in these things. The list is making any statement, whether orally or in the writing, or by visible representation, including by means of electronic records, which falsely represent that the goods are of a particular standard, quality, grade, composition, style, or model. The lifestyle being represented in all these advertisements. Falsely represent that the services area of a particular standard, quality, or the grade. Like almost all of them say that they are the building something extraordinary luxury. Falsely represent any rebuilt, second-hand, renovated, reconditions, or old as new. Represent that the goods or services have sponsorship, approval, performance, characteristics, accessories used or for benefit which such goods or services do not have. Showing the photo of the completed things and then not providing them without any express disclaimers. Represent that the seller or the supplier has a sponsorship or make false misleading representation concerning the need for or usefulness of any goods or services. Gives to the public any warranty or guarantee of the performance, efficiency, or length or the life of the product or any goods that is not based on an adequate and proper test thereof. Last forever. Is the representation normally made, provided that where the defense is raised to the effect that such warranty guarantee is based on adequate proper test, the burden of the proof that such defense shall lie on the person raising such defense. So without testing, you cannot say that a particular construction will last for so many things, and if it has been done, then the burden of the proof lies on the builder. Make to the public a representation in the form that purports to be a warranty or guarantee of the product or any goods or the services, a promise to replace, maintain, repair, article, etc. if such purported warranty, guarantee, or promise is materially misleading. So anything which is misleading also falls within the vice of these provisions. And the definition is very long, so we can omit rest of the but you can skip it. Then one of the important definition is the price, the bargain price. The bargain price is which is agreed between the buyer and seller. So I'll just read that. The thing is, when there is an asterisk mark when the people come out with the project to say that the 2 crore and 2.5 crore, and then they say disclaimer. So it says that a price that is stated in any advertisement to be a bargain price, any reference or ordinary price. If it is misleading, that is also covered. So we are skipping few of those sections, and then we have to come to the chapter 2. So I think so far we have covered the definition section, which is the longest one. But at the same time, this was the section which covered like major theme of the act. Any questions so far?
I got a question to ask.
Yes, sir.
In your initial opening remarks, you mentioned that to the consumers. I'm specifically drawing your attention to companies who are undergoing CIRP under IBC, and it is a real estate company wherein cases have been filed against this company or corporate debtor prior to commencement of CIRP.
Right.
In forums like RERA and NCDRC. Now, what is happening is that RERA has, since there is a non-obstantly clause that is as per section 238, the provisions of IBC will prevail.
Right.
The RERA has accepted that and mentioned in their order that since the company is under CIRP, we decline to pass any order. But unfortunately, in one of the cases, NCDRC has, being unaware of the insolvency proceedings, they have passed the order in favor of the consumer.
Okay.
Now the flat buyer comes to the CD and he demands the possession of the flat or the unit from the RP.
Okay.
And since moratorium is in place, RP is unable to give the possession to the flat buyer.
Okay.
So there is a dilemma as to which provisions will prevail, whether IBC provisions will prevail or NCDRC's order will prevail, which clearly states that the possession should be given to the consumer or the flat buyer, which cannot be given under moratorium because moratorium restricts an obligation or other RP is restricted from alienating any asset of the corporate debtor, either in the form of inventory or any other form. So what is your view on this?
Okay, Avinash ji.
Yes, sir.
So if you can switch on the camera, I'll answer if it will be help to me. So
yeah, sure, I'll do that.
So like this is the regular problem with most of the project for one reason. What is the reason for the problem and what is the solution? I will give you all the answers. The problem that when the RP is taking over all the data, they are not given the complete data of all the home buyers, so they are not aware what the proceedings are going on. So what happens that despite the CIRP has commenced and 14 moratorium has come into effect, the RP is not representing or not sending his lawyers to say that the 14 moratorium has come. So now I am the custodian. So the court not having the knowledge of that particular order of the IBC keeps on proceeding with these matters and the orders are being passed. So that is.
Sir, I'll just interrupt here. In this company, this real estate company, there are more than 400 cases which have been filed in RERA. So it is virtually impossible for an RP to inform RERA that against these 400 cases, the company is undergoing CIRP.
Yeah, you are absolutely right. I'm not saying that something wrong has been done. I'm saying this is the primary reason that the court who is passing the order is unaware of the section 14(1). Secondly, the NCDRC has passed a wrong order. The RP should file a review or an appeal, whatever is advised by his lawyer, depending upon the fact in those cases. Okay. If he has not varied the order, the people will file the execution and then another someone will come to the doorstep of the resolution professional. So that's the solution.
Yes, that's right, sir.
Now, which act will prevail? There is no doubt as of today, it is IBC will prevail. The only thing which is in the, which is supposed to be taken care of is that the resolution professional should appoint somebody to challenge that order in the way it has been advised. Because being a custodian or appointed under a law, the resolution professional cannot say that I will not comply the order because I feel it is illegal.
Okay.
So in order to protect himself before the consumer forum and the IBBI, he should take immediate action.
Okay, noted. Thank you.
Welcome, sir. Any other question? I don't hear, so I feel that the people got the, either everybody is having the good snacks or they got all the answers. Any other questions so far?
No, sir. Thank you.
The Gaurav Sharma ji has his hands up. I don't know whether he wants to ask something or not. Or it's unintentional. It seems unintentional. Okay, so I'll proceed further. The chapter 2, Consumer Protection Council. So this is the regulator which has come into effect. And those people who are actually looking at the screen are can see that there are no headings in the sections, but there is something which has been given in the margins of the sections. So when you buy the acts from the shop, then these margins are converted into the headings. So the people who read the basic act, they know that these headings are called margin notes. And from the margin notes, you get to know that what is the content of that paragraph. So those are something like the statutory interpretation thing, but it helps a lot when actually you are reading the notification. So the Central Consumer Protection Council, this is one of the regulator which has come into the effect. Object is obviously the protection of the consumers. I don't think we have much of the time or the relevance to read all of them. Then Central Consumer Protection Authority. So establishment of the Central Consumer Protection Authority is there. Then there's a qualification, vacancy, appointment, procedure, investigation. Now the next thing is investigation wing, which is important. So like CCI, like IBBI, like Telecom Regulatory Authority, perhaps, I don't know whether he has a power or not. There is an investigation wing even in the Consumer Protection Act. So what exactly the composition? Uniformly in all these acts, there is a Director General who is responsible for the investigation which is being carried out. He has been assisted by the people of his team. There is an entire team who is doing that. And they make the reports and file the complaints before the authority. This is the unique feature of most of these legislations. And the Consumer Protection Act is no different than this. So anything can be investigated. The District Collector Complaint Authority. So the District Collector, the complaint can be filed, then authority, power, central authority, all these things like you can, whenever you have the time, you can go through it. One thing which is really typical about these legislation is they are not only law enforcing agency, but they are also promoting the consumer rights. That responsibility has been casted upon them. So they are, in a sense, they are helping to make sure that the market performs in a way that there is no disruption of the services. At the same time, the consumers are protected. So there is a long list and there are various powers which has been given to them, which can be broadly categorized into one. They have a power to investigate and enforce the orders, and secondly, they have to promote the consumer protection. They can do the search, seizure, ask the people in their authority, they can take evidence, the statements are being recorded. So typically, a gist I can give how the process moves in all these acts. So normally they start the investigation on a complaint or some newspaper report on their own. Once the report is started, a notice is issued to a person against whom these allegations are there. Once the notice has been issued, a team of officials has the power, and normally it does go. They takes out all the records from that particular authority. Then these records are brought back to the authority and analyzed. Based upon the analysis, a charge sheet or a memorandum of charges or whatever it is being prepared, that sheet is again given to the officers of the company to say that, okay, we have found these allegations to be correct. What is your response? Post that response, there is a kind of hearing which takes place. Exactly, it's not a hearing in the judicial sense, it's a hearing in the sense like it's a communication between the investigation agency and the company where the allegation is made. You can say that it's a part of the investigation. And then that report is submitted. And on the basis of the report, the penalties are being imposed. These are the general themes, like how these investigations do proceed in all these acts. So if once that order is passed by that competent authority, if a person is not satisfied with the order so passed, then he can go into the appeal and etc. So I'll just, for the sake of example, I'll take an example of, say, biscuit. If somebody is advertising that this biscuit contains something which will be really healthy, that compound to be found to be like non-existent in that particular product or harmful to the health, and it was wrongly promoted by the thing. It's very difficult for one person to fight that for on the behalf of a packet, on the packet which is size of, say, rupees 2 rupees or 5 rupees packet. So in order to check those small ticket cases, this mechanism of the complaint is very effective. So this has been done in order to ensure that sometimes the consumer and the person who is giving the services, there is so disproportionate between the economics that they don't pursue even the complaints. So in those cases, it's really helpful. It's also helpful where the person himself doesn't want to pursue it, and he is able to convince the authority that this is unfair trade practices or something wrong has been done. But it reduces his cost and the matter goes with the authority and the company, and that's how it is being decided. So this is the general mechanism: accounts, audit, funding, etc. Now, this is the third body, which is the Consumer Dispute Redressal Commission. This is an adjudicating authority. So this is like earlier the district forum. So now the consumer is still a district forum. So apart from this, whatever we have seen above, that did not exist in that form which is mentioned in this act in its predecessor act. It's a completely new. There was no power to investigate and access, and I think there was hardly any investigation which was done by anybody prior to that, but this has been done in this Consumer Protection Act. So there is always a precedent, there is a composition. What is the most important thing what they have done in this act, that they have raised the pecuniary jurisdiction of the district consumer forums. All these acts normally has the provision who can be appointed, who cannot be appointed, etc. The important section is 34. Subject to other provisions of this act, the district commission shall have jurisdiction to entertain complaint where the value of the goods or services paid as a consideration does not exceed 1 crore rupees. That's a significant difference from the earlier act, where only few people used to go to the district forum because it was few lakhs, like none of them was district forum. Most of them are either state forum or directly the NCDRC, because either the flats cost around between 20 lakhs to 1 crore or more than a crore. So more than a crore automatically came to the NCDRC, and between them came to the state forum. Now even a district forum has the pecuniary jurisdiction to decide this dispute, and this is the marked distinction. Provided the vessel deems it necessary, it may prescribe such other value as it deems fit. A complaint shall be instituted in district commission within the local limits and whose jurisdiction the opposite party or each of the opposite party, where there are more than one at the time of the institution of the complaint, ordinarily resides or carries on the business or has a branch office or the personally works for gain. So obviously it can be registered where the builder is working, or it's where the registered office is. Any opposite party where there are more than one at the time of the institution of the complaint actually and voluntarily resides or carries on the business or has a branch office or personally works for the grain, provided that in such a case the permission of the district commission is given. So where there is a multiple branch office of any company, then it can be sued in multiple forums. The cause of action wholly or in part has arisen. The complainant resides or personally works for gain. So this is the game changer. The district commission shall ordinarily function in the district headquarters, may perform the function of such other places as the districts and etc. The thing is, now if somebody has sold a flat to a person who is residing, say, in Kanyakumari, and the project is located somewhere in Ladakh, then it's possible to file the consumer complaint in the Kanyakumari. So the mis-selling and the amount of litigation a person likely to face under this new act is much more than what was in the prior act. Manner in which a complaint shall be made. There is a marked departure here as well. So the complaint in relation to any goods sold, delivered, or services provided or agreed to be provided may be filed with a district commission by a consumer to whom such goods and sold, who alleges unfair trade practices in respect of such any recognized consumer association, one or more consumers, central government. The most important part, provided that a complaint under this subsection may be filed electronically in such manner as may be prescribed. So going forward, all the digitals in all the judicial forums are going to be digital. There is no need of the paperwork and etc. And the people will start filing, like there is a golden rule which says that if you make the system efficient, it has to do more amount of work. So with the electronics, the number of cases are bound to rise, and the people will start filing soon all anything, any deficiency on the online thing. This is going to be a game changer. Then proceedings before the district commission. Every proceedings before the district commission shall be conducted by the president. On the receipt of the complaint, I'm reading subsection 2. On the receipt of the complaint, the district commission may order admit the complainant for being proceeded or with reject the same, provided that a complaint shall not be rejected under this section unless an opportunity of being heard has been given to the complainant. Provided further that the admissibility of the complaint shall ordinarily be decided within 21 days from the date on which the complaint was filed. I don't know whether they were not able to adhere the 14 days timeline. So what will happen this 21 days timeline, but this is there. Where the district commission does not decide the issue of admissibility of the complaint within the period so specified, it shall be deemed to have been admitted. So that's a deeming fiction which is there. Reference to the mediation. So this is what we have seen in the definition section, and now it is coming out again. At the first hearing, the complaint after its admission or any later stage, if it appears to the district commission that there exists an element of a settlement which may be accepted to the parties, except in such a case as may be prescribed, it may direct the parties to give in writing within 5 days consent to have their dispute settled by mediation in accordance with the provisions of Chapter 5. So if the parties are agreeable, the court can refer them to the mediation. Probably the people can take benefit even where the decrees has been passed and executions are pending during the pendency of the projects or pre-project or post-projects and pre-packaged insolvencies and everything. Where the parties agree for settlement by mediation and give their consent in writing, the district commission shall within 5 days of the receipt of such consent refer the matter to the mediation. And in such case, the provision of relating to the mediation shall apply. Procedure on admission of the complaints. This is also the process of audio alteram partem. Nobody should be condemned unheard. So this process comes into picture. The district commission shall, on admission of the complaint on the respect of a case referred for the mediation on failure of the settlement by the mediation, proceed with such complaint where the complaint relates to any good. The district commission shall. A notice is issued, the replies are invited, etc., etc. This is a long drawn process, which I think we can skip for the time being and pass on to the other section. But if somebody,
Sir,
yes.
Sir, as you said that it's a game changer. Now we can file the complaint through e-mode only. Okay. Will the government have the proper infrastructure to address all the complaints?
Sir, could you switch on your camera so I can see who is speaking? I will answer it immediately. It will help me a lot. Ashish ji, Avinash ji, who is speaking? Hello. Deepak ji. Hello. Can you hear me, sir?
Yes, sir.
Yes, sir. Deepak ji. Okay. So the going forward, all the complaints are going to be digital for sure. The Supreme Court has 100%, like I'm practicing in the Supreme Court. So Supreme Court has 100% digital filing. Delhi High Court has 100% digital filing now. The DRT, they have come out with a notification for 100% digital filing. It happened, I think, last month only. And some of the people filed a SLP before the Supreme Court to say that you should delay the process because there is a lack of infrastructure with the people who wants to file the complaint. The Supreme Court simply said nothing doing, it is going to happen this way only. In the Consumer Protection Act, when they're drafting the legislation, they anticipated that now it's impossible for the consumer forum to handle the paper complaints, because even in the earlier act, there was a provision that anybody can write a letter to the consumer forum and it will be treated as a complaint. And many of those cases, the people actually just wrote the letters of their complaints and that became a complaint. It is so informal. So this is bound to happen in this case, and 100% guaranteed in the few years, they will close the option of the physical complaint, just as they have done in the DRT. DRT, they have even closed the option that you can do it physically. In the Supreme Court, still there is an option. In High Court, there is an option in certain jurisdiction and there is no option in certain jurisdiction. But in Consumer Protection Act, it is going to happen, and I have least doubt that the government's capability to not to do it, because electronically it's cheaper for the government, easier for the government to monitor, and like the entire process remains in the checks and balances. So that's 100% sure.
In keeping in the mind of, in the DRT and consumer, cases are more in consumer because in the we have a lot of whole population in the country where consumer in the DRT are very less cases, only bank cases or individual cases. In that perspective.
Yes. So what is happening in this act is that they have segregated the amount of disputes. So the cases which is less than 5 lakhs of rupees, there is a different treatment in this act. And then there are above which are different treatment. In any case, a person cannot be denied of the right of filing the complaint merely because it's electronic. Electronic. So it's going to happen. How it is going to happen is yet to be seen, but your concern is genuine. But going by the experience, I feel that it will be electronic only and the physical filing will close.
Thank you, sir. Thanks.
Thanks for the question. It was a very relevant question and it was a really concern. So the concern sprang from the fact that if somebody doesn't got, say, tea ordered from a shop which is not sweeter enough, and he can just write an email and it will go to the complainant, what will happen to those complaints? So the people are conscious of this fact that as soon as it's electronic, there will be number will be moved. So hopefully they will calibrate the system. In any case, it's going to happen. The right was existed there and they have just changed it, the form. Nothing. This earlier the people were not writing the letters, that's it, but the right was there in the old act itself. Yes. So the next thing is no proceedings. So this is the complete procedure which has been provided. Basically, the procedure is the same in most of the courts, irrespective of the nature of the court. They follow the rules of natural justice. As soon as the complaint is received, the first thing is that a notice is issued to the other side. The other side gets the right to respond in a certain time frame that, okay, whether he has done this or not. Once that reply is received, the first party who has filed the complaint can say that these are the things not correctly stated in the reply. So that's called a rejoinder. Once that rejoinder comes, then there is a process of taking the evidence. The evidence affidavits are filed by both the parties to say that I state this. There is a statement and accompanied with the document by both the parties. Once those evidence is collated, then there is finally there is a stage for argument where the people address the argument, and thereafter there is a written submissions if so required and the judgment is pronounced. The significant departure here is, in this case, is that there are accredited laboratories from which the consumer can obtain the report and file. This is something different which has been like fortified in this act. So then there is a finding of the district commission. So what reliefs, just a second, how much we have covered. So, okay, so findings of after procedure findings. So what relief can be given by the district commission is given. Removal of the defect, replacement of the goods, to return the complainant the price, to pay such amount as may be awarded by it as a compensation to the consumer, provided that the district commission shall have the power to grant punitive damages in the circumstances as it deems fit. So these powers does not exist in the IBC. So if somebody wants the harassment compensation, then they have to go to the consumer forum. So there are two things: harassment compensation, which is a compensatory in nature, and the punitive damages. Punitive damages are something which is over and above the compensation, and the court feels that the conduct is such that this party should be punished, so he should not commit this offense against any other person in the future. So those are the punitive damages. Then to pay such amount as may be awarded compensation, to remove the defects, discontinue the unfair trade practices, not to offer the hazardous goods, withdraw the hazardous goods, etc. So any kind of the order can be passed in the favor of the consumer, like the scope is very wide. Then there is a minimum threshold, which is like just after clause K, you can see, provided that the minimum amount of sum so payable shall not be less than 25% of the value of such defective goods sold or services provided, as the case may be, to such consumer. So that's something very significant. It's not something which is a mirage compensation in large deals. To issue a corrective advertisement to neutralize the effect of misleading advertisement is also there. So not only there would be a damage, but also there will be a implication of the public perception, where they are supposed to say that this is a mistake, or this is something which we have done wrong and this is the correct position. There is a fund which is established, which is ultimately goes for the benefit, like this provision has come in many of these legislations now. Okay. So then section 40 is important. Review by the district commission in certain cases. The power of the review is a statutory power. Those who are dealing with the cases in and out, they know that unless it has been conferred by the statute, the district forum or any forum does not have a power to review its own orders. So even the NCLT does not have the powers. Most of the people, you are resolution professionals, and you know that if there is an error crept in the order, which is not arithmetical or something in nature, then the only remedy is to approach the NCLT. But the district forum has been given the power to review its own orders, certain cases. So the district commission has the power to review any of the order passed by it if there is an error apparent on the face of record, either on its own motion or an application made by the parties within 30 days of such order. Appeal against the order of the district commission. Obviously, the state consumer redressal forum, there is an appeal within the period of 45 days from the date of the order. So the timelines are similar to the IBC. Not exactly same, but still similar. There is some similarity. Earlier, the ratio was the 30, 60, 90. Now it has gone down to the 45 days. Then there is something which is called the barriers to the appeal. So we must read the appeal provision very carefully. The barriers to the appeal is, as we will get to know, there are provisions for the deposit of the amount. So I'll read the section and that will make the things crystal clear. Any person aggrieved by an order made by the district commission may prefer an appeal against such order to the state commission on the ground of the fact or the law within the period of 45 days from the date of the order in such form and manner as may be prescribed. Provided that the state commission may entertain an appeal after the expiry of said period of the 45 days if it is satisfied that there was sufficient cause for not filing it within that period. Provided further that no appeal by any person who is required to pay any amount in terms of an order of the district commission shall be entertained by the state commission unless the appellant deposits 50% of that amount in the manner as may be prescribed. So for the appeal, there are consequences. The people cannot file simply appeal to harass the other party. So a trend has been observed where there is an unequal bargaining power. The power party who have more financial power, what they do, they keep on filing the appeal till it is decided by the Supreme Court, and then they pay the amount in the execution. And for that period, the people are unable to suffer the pain. So in many of these legislations, these provisions are coming that the person who is filing the appeal, prima facie or to some extent, there is a problem with his case. Therefore, he must deposit something in the court to safeguard his right. That shows that it is not for the sake of filing the appeal, but there is something genuine. So in completely frivolous cases, the incentive to file the appeal is lost. And that's why these provisions are being introduced. Then, provided that no appeal shall lie from any order passed for the settlement. So in case there is a mediated settlement, there will not be an appeal. Establishment of the State Consumer Dispute Redressal Commission. So it will be as in the state, then there is a provision of the, again, the qualifications, salaries, transitions, officers, employees. For our purpose as a professionals, the important section is jurisdiction of the State Commission. The subject to other provisions of this Act, the State Commission shall have jurisdiction to complaint where the value of the goods or services paid as consideration exceed rupees 1 crore, but does not exceed rupees 10 crore. There are hardly any flats which is going beyond 10 crore. So the original jurisdiction of the NCDRC is limited only for very high volume dispute, very high disputes, and there is no reason for the people to approach that much. So they are trying to minimize the litigation at the top of the pyramid. Then complaint against unfair contract where the value of the goods or services prescribed does not exceed 10 crores, appeal against the order of district commission within the state. Then they have the power to call the orders and etc., which is existed in all other provided in all other cases. Again, the cause of action and the complainant resides also. Transfer of cases is also there. Procedure applicable, review of the State Commission, and appeal to the National Commission is the next section which is relevant for our purposes. Any person aggrieved by an order made by the State Commission may prefer an appeal against the National Commission within the period of 30 days from the date of the order, in such form and manner as may be prescribed. Then there has to be a delay, which is the ground has to be given. Then again, there is a provision for the 50% of the amount which the court can ask for preferring the appeal. And the appeal lies only on the substantial questions of the law. So it's not matter of the right. In National Commission, it has to be a question of such, otherwise as provided any other law for that. An appeal shall lie to the National Commission from any order passed in the State Commission if the National Commission is satisfied that a case involves a substantial question of law. In an appeal involving question of law, the memorandum shall precisely state substantial question. So unless there is a substantial question, they may not entertain the appeal. Then there is a process for hearing, establishment of the commission, and jurisdiction of the National Commission. This is also important, where the complaints and value of the goods or service paid is considered exceed rupees 10 crores. Is the commission, then the appeals from the State Commission and any appeal against the order of the central authority. So from regulator, so that this can be categorized that in the regulator directly appeals come to the National Commission, then the appeals from the State Commission, then unfair trade practices, the original complaint of more than 10 crore will come to the National Commission. Then the powers of the commission, the procedure is also same. These are the repetition provision. Review power has been given to all the forums, and then vacancy and etc. These provisions can be ignored. So a good part of it is just procedural. Then there is one thing, expert to assist the National Commission or the State Commission. Where so there are many disputes which are not in the domain of, like the judges are not qualified to decide many of the disputes because they haven't have the technical education of that nature. Suppose there is a dispute relating the worthiness of the building to withstand the earthquakes. So they definitely need somebody to say that whether that kind of mechanism has been installed, whether that mechanism has installed can withstand the quake of that much of magnitude or not, or anything like that can be seen by the commission with the help of the expert. So the National Commission or State Commission, as the case may be on an application by the complaint or otherwise, is of the opinion that involves larger interest of the consumer, it may direct any individual or organization or expert to assist the National Commission or State Commission, as the case may be. Appeal against the National Commission is to the Supreme Court, and that's within 30 days. So it's also a very time-bound process. And again, there is a bar of deposit of the amount. So at every stage, that amount has to be deposited, and finality of the limitation period and etc. The limitation for filing the consumer forum complaint is always 2 years. Administrative control and etc. So far we have largely covered all the relevant provisions except for the enforcement. So there is a known compliance and the penalty has been increased significantly now. So every order can be enforced as a decree of the civil court that is there. Whoever fails to comply with any order made by the district commission or the state commissioner or national commission, as the case may be, shall be punished with an imprisonment for a term which shall not be less than 1 month, but which may extend to 3 years, or with fine which shall not be less than 25,000 rupees, but which may extend to 1 lakh rupees, or with both. So this is then there is an appeal against the order passed under 72 etc. for the penalty. Then the provisions regarding mediation. So in the mediation provision, there will be a cell which will be dedicated cell, which will be empaneled mediators who will decide the dispute. Just a second. So far, any questions? I assume that everybody is there. I think that my assumption is false, but still for the sake of it.
Yes, there.
Thank you, Deepak. Sometimes it gets really monotonous, or when not a single person is showing his face. So the speaker loses the charm what to speak, what not to. Anyway, that is how it works. So the empanelment of mediator, all of you are IPs, you can develop your profession as a mediator as well. So there will be a mediator panel in all consumer forums, all the high courts, all the Supreme Court. I'm empaneled in the Supreme Court. You can go to the district forum. These are the things which are going to come. So mediation is something, a structured process. And as of now, like just for the sake of the benefit, those who are interested to develop this stream and wants to use this thing in their CIRP proceedings, it's a 40-hour structured course driven by the Supreme Court. There is a committee in the Supreme Court which drives it. And the training is imparted in the districts and high courts and etc. And the mediators are given the accreditation that they have undergone this 40 hours training, and then they are appointed. These people do not decide the dispute on the merit, but if there are some common grounds, they come with some sort of resolution. The advantage of the mediation is that once the party signs the mediation settlement, then there is no appeal.
Just a minute, sir. You said 40 hours training. Who are eligible to become the mediator? Anyone who professional, or there is a restriction?
Any person that's the time slot there is entitled to become a mediator. Okay, so right now, like this window is opened in the High Court and the Supreme Court and district forums. So I have seen in the district forum, there are people who are not even any professional, like psychologists and psychiatrists and coming from different stream has become mediators. So there is no bar that only a certain professional can become a mediator. And going forward in the Arbitration Act, there is a provision which prescribes the future qualification. So far, there is a 40 hours training only. Once those provisions get notified, the further qualification criteria will come. I'm sure that that will be more rigorous than what is today, but they are definitely going to come. So even in the CIRP proceedings, if there is a possibility of the mediation, people can get a settlement, and that will be binding on the people. And the RPs have the power to do so, so they can explore this thing, because that puts many dispute to the rest. Then product liability, of course, there. And I'll just come to this last thing. So we have covered, except for the offenses and penalties, 6 months, 10 months, and then miscellaneous provisions. So this is the end of the Consumer Protection Act. If anybody has questions, then fine, then we will move to RERA. Any questions, sir, so far?
No, sir, I think we can go ahead.
Thank you. Thank you, Avinash. Okay. So the next act is, Avinash, you can see the BEAR Act on the screen?
Yeah, sir, I can see.
Okay.
Yes, we can see, sir.
Thank you. Thank you, Deepak. So the RERA has a same theme as the Consumer Protection Act, but with specific to the industry. The real estate industry is very typical. And because it's typical, it requires a legislation for itself. So not only this, there are many industries like telecom, electricity, where there are specific legislation governing those industries and consumer within those industries. IBC was made as one size fit for all. And at very early stage, the legislature and the courts realized that this cannot be applied to the real estate industry in a straitjacket format. So one of the first change which was brought for a particular industry, and so far the only change which has been brought for a particular industry, is for the real estate industries, where they have laid down certain threshold for the real estate sector. Because this industry has its own nuances. The nuances starts from the very beginning, where there is a procurement of the land, which is always contentious, highly litigating thing. Be it an allotment from an authority, be it from the licensing, be it from the labor, be it from the passing of the maps. It was entirely driven by the cash economy. The people were pumping their money into it for reasons other than a genuine buying agreement. So there were many projects in which most of the buyers were not from Delhi NCR, like 90% of the buyers from a far-flung location, Dubai, Northeast, even West, South, and hardly any people. But so it was sold as an investment option to the people rather than a thing of need. And because of those nuances, those compulsions, many practices which were developed in the sector which was not so healthy, like right from the advertisement, like the people did not have, and they envisaged the project and advertised in the market, and thereafter they started buying the land or asking for the people to collaborate. Even after the collaboration, the land was not sold to the company who is building it. The collaborator said that give me the FSI or a built up area and I will sell it for myself. Once that project was built up, again it was given to a third agency to sell it. In between, there was huge amount of the transaction which happened in the cash. So all this undervalued and overvalued. So if the payment has been, there is a huge, like those who are dealing with the CIRP will realize that there is a significant gap in the different amount received for a particular flat which are sitting next to each other. So these were the systematic vices, cannot be attributed to any one person or another person, but that was there. So, and there was another practice of the mis-selling. Mis-selling happens when you promise something and you give something else. So the flat numbers were further changed. The flats were sold not on the carpet area, but the overall area has been taken into consideration. Then there was a significant delays. The amount of one project was utilized in the another project. It was not even utilized at all in some of the projects, siphoning of the funds, etc. Then there was no accountability, and the progress-driven building construction progress-driven plans were like put on the dash, just on the paper, and never followed, etc. So because of all these vices, the government came out with this particular act. The challenge with this act was that the land is the subject matter of the state. It is not a central subject matter. Since these vices were spreading across the nation, then there is a central act which has been brought where the state has been given the power to administer the act. So there is a uniformity in the act, and there is a different kinds of rules which are mostly similar, but there are some variation depending from one state to another state. So that's the short background of the act. It has been divided as any other act is divided into the chapters. The first chapter is the definitions. We will go through the important definitions. Second is the registration of the real estate projects and the agents. So both are required to be registered. Function and duties of the promoters, the rights and duties of the allottees, the real estate regulatory authority. So that has come into existence and residing. Then the central council, the appellate tribunals, then offenses and penalties. The structure is the same. So first, let's go to the definition section and let's go through some of the important definitions. But prior to we go to the definition, we must see the preamble. What was the objectives? Because this is the guiding principle which runs through the entire act. The act to establish the real estate regulatory authority. So another regulator for regulation and promotion of the real estate sector. So that has the responsibility to develop the market and protect the market, and to ensure sale of the plots, apartment and buildings, as the case may be, or the sale of real estate project in an efficient and transparent manner. So what was missing is the transparency, and to protect the interest of the consumers in the real estate sector. So it's the consumer in the real estate sector, and to establish the adjudicating mechanism for speedy dispute redressal, and also to establish appellate tribunal to hear the appeal decision, directions, order of the real estate regulatory authority, adjudicating authority, etc. So all those things were not present in the earlier act, and therefore these things were, there was no actually earlier act. This is for the first time this mechanism was brought in the RERA Act. It applies to the whole of India. The Jammu Kashmir has gone, the exception. Yes, so here also we will see the similarities between the Consumer Protection Act and this act. Advertisement. Definition is given there, definition is given here. So they are always concerned the way it has been advertised. Means any document, prescribed advertisement, and etc. Then the next definition is agreement for sales, mean an agreement entered between the promoter and the allottee. Now the most important definition is for the IBC people is the allottee, because these definitions are not given in the IBC, and they import these definitions from the RERA Act. So what is an allottee? Allottee in a real estate project means the person to whom plot, apartment or building, as the case may be, has been allotted, sold, whether freehold or leasehold or otherwise, transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transferred or otherwise, but does not include a person to whom such plot or apartment building, as the case may be, given on the rent. So the important distinction between this definition and the Consumer Protection Act is the commercial purposes. There is no exception of the commercial purposes in the definition of the allotee in the RERA. A person has bought 2-5, builder can't take the defense that he is no longer an allotee. He can take a defense there. He can't take a defense here. That's one of the things which is one must keep in mind. Then it's an allotment made by the promoter. So the definition of the promoter becomes really important, and it need not be sold. It's just an allotment is sufficient. If you compare this definition with the definition under the Consumer Protection Act, then consideration part paid or promised to be paid. Here it is an allotment. Why it is an allotment? Because there was a concept of the TP Act where an agreement to sell. So there were defenses that there was no agreement to sell and etc. So here is the allotment is sufficient. Apartment. So people were using home buyers as a common parlance word. The statutory word which has been used for the purpose of the IBC in the RERA Act is the allotee and the apartment. And the apartment can be block, chamber, dwelling unit, flat, office, showroom, shop, godown, premises, suite, tenement unit, or any other names, means a separate and self-contained part of an immovable property, including one or more rooms or enclosed spaces located on one or more floors in the building plan, land, and access. And it can be used for the residence, shop, showroom, for carrying on any business, occupation, profession, or trade, or any other purpose used for ancillary purpose specified above. So this is what the statutory definition is. Now going back to the appellate tribunal, that's those definitions are there. Then building, and then the important definition is carpet area. The definition of the carpet area is very simple for a layman. A place where you can actually lay a carpet, and if you measure that area, that will be regarded as a carpet area. So that's what the normal name comes from, the carpet area where you can do it. But for the statutory purpose, it's like this, means net usable floor area of an apartment, excluding the area covered by the external walls. So walls are excluded. Under the service shaft, exclusive balcony, veranda area, and exclusive open terrace area, but includes an area covered by the internal partition walls of the apartment. So that's what the carpet area is, not the covered area for which the people normally do this. Explanation is given. For the purpose of this clause, the expression exclusive balcony, veranda area means an area, the balcony, veranda as the case may be. So those are the areas, but when as an IP, you are scrutinizing the contracts, and there might be instances where you feel the difference might be relevant in some cases, not in all areas. So similarly, where there is no carpet, there are common areas. Company, competent authority, completion certificate is important. Completion certificate means the completion certificate or such other certificate by whatever name called, issued by the competent authority, certifying that the real estate project has been developed according to the sanctioned plan, layout plan, and specification as approved by the competent authority under the local laws. So there was numerous cases in which the question has arisen that there are no completion certificate, then people are still residing in the forcing the RP to give the possessions. So here that definition comes the relevant, then there are opinions given left, right, and center. Those questions are still open in some of these cases, but that's how the RERA becomes important for the insolvency proceedings. Then another important definition is interest Interest. Interest means rate of interest payable by the promoter or the allottee as the case may be. So in some cases now it has been defined in the rules. But when you are calculating the claims, the people are asking like what, sometimes the people are claiming 24 interest, sometimes some people are claiming as per the builder buyer agreement and etc. So those were the disputes which are coming. But what the statute said, the rate of interest chargeable from the allottee by the promoter in case of default shall be equal to the rate of interest which the promoter shall be liable to pay to the allottee in case of default. So there cannot be that I will give you on the square area if there is a delay, 5 rupees per square feet if there is a delay, but you pay me 12% of the installment if there is a delay of installments. This is the section which deals with it. The interest payable by the promoter to the allottee shall be from the date the promoter receives the amount on any part thereof till the date of amount or part thereof and interest thereon is refunded. The interest payable by the allottee to the promoter shall be from the date of allottee's default in payment to the promoter till the date it is paid. This definition becomes very relevant when actually the claims are being scrutinized. Internal development works, not very important, but important in the sense that now in some of the projects, the people are giving bare shell units. Like there was a promise to pay the entire constructed unit with all the amenities, but in the resolution plan, they are modifying it. Occupancy charges. This is also a contentious issue. So even before the CC, whether there can be an occupancy charges, occupancy certificate and the charges. So occupancy certificate means a certificate which has been issued. Person, almost same definition. Planning area. Then another most important definition is the promoter. This is still a contentious issue because the promoter has not been defined so far in the IBC. This IBC only follows the waterfall mechanism in which there are shareholders, creditors, debtors, etc. But there is no definition of the as such of the promoters for the real estate companies in the IBC. So what it means? A person who constructs or causes to be constructed an independent building or building consisting of apartment or converts an existing building or part thereof into apartments for the purpose of selling all or some of the apartments to the other person and includes his assignees. A person who develops the land into the project, whether or not the person also constructs the structure on the plot for the purpose of selling to the other persons and all some plots in the said project, whether with or without the structure thereof. So the people who have given the land to the developer for constructing these real estate projects are promoters within the definition of the RERA. How they are supposed to be dealt with in the IBC is the question, and how their rights are still being adjudicated. Sometimes there are decisions of the NCLAT where they are classified as an other creditors as of now, but what would be the fate ultimately is to be seen. So that's why the definition of the promoter becomes important. It also important because of the remedies available to the people. So the people in the RERA can even go behind the landowners even today without there is no problem. They can actually go in the RERA. There is a possibility of the argument and it can be done, but that can't be done in the IBC. IBC, they take the plea that the company is a separate entity and we are the separate entity. Therefore, we should not be held accountable for the faults of the company. So that's the definition of the promoter. Then any development authority or any other public in respect of the allottee of the building apartment, any apex state cooperating housing society. Then the fifth is also important. Any other person who acts himself as a builder, colonizer, contractor, developer, state developer, or as any other names or claims to be acting as a holder of the power of attorney from the owner of the land on which the building or the apartment is constructed or plot is developed for the sale. This definition is important when there is a third company for selling and there is one company which is for building. So who is the promoter? What are the liability? So this clause 5 gets attracted. Then prospectus means everything which has been noticed, circular, any other thing. Then real estate agent. These people are not so far. There are some controversies whether the online seller should be recognized as a real estate agents or not on registration. These are the provisions but for the IBC purposes, they are not that much of relevance. The real estate project, this definition is relevant because in many of the insolvency proceedings which are going on, there is a problem where the project as such was not registered before the act came into force. So there was no project-wise registration, and there is a challenge to the people to find out 100 and the 10% of the project. So let's go to the definition of means development of the building, and there are project-wise insolvencies as well. The question, like now there are people like NCLAT in some of the cases they have allowed project-wise insolvencies, and there is a proposed amendment in the IBC where it says that there has to be project-wise insolvencies in the real estate companies, like the court can allow it. There is a statutory recognition of this kind of thing in the proposed bill. So what is the project aims? The real estate project means the development of a building or a building consisting of apartments or converting an existing building or part thereof into apartments or development of land into plots or apartments as the case may be. For the purpose of selling all or some of the said apartments or the plots or the building as the case may be, and includes common areas, development works, all improvements and structures thereon, and all the easements, rights, apparent belonging thereto. It doesn't say actually the defining criteria, which are the contentious thing. Whether there are two parcels of the land which are situated adjacent to each other, and there are towers built upon them, which may be separated, which may have a separate license or the same license, which are completely differently encompasses and surrounded by the boundary walls, whether they will be regarded as a separate project or the same project. Whether within the same license there is a hotel and service apartment and other is the residential apartment, can they treated in the same? So all those questions are to be answered and litigated upon when those relevant things comes into the picture. Sanction plan, obviously. Then registration. The provisions regarding registration of the project. Any questions so far? We have covered like 2 chapters of this thing. It will be really helpful if somebody can say no, because there is not a single phase.
No, sir, we can go ahead.
Go ahead, sir.
Thank you. Thanks for answering. So the registration was made mandatory in this act. There was a dispute regarding whether all the projects which were commenced prior to this, when this act came into effect, required to be registered. And now the law has been fairly settled that if any of those projects were not completed before this act came into force, then they are required to be registered. So there are multiple judgments in this regard. Still, in many of the IBC cases, the projects are not registered. So the people are taking care of it in the resolution plans. I don't know what will happen when the people go into the liquidation and etc. Then still they are supposed to get registered. There are resolution plans in which the people are saying that the RERA will not be applicable, and those were challenged. But the registration is an important part of it. Application of the registration of the project. So the impact of the registration is directly happens that as soon as something is registered, then that particular information is available on the website. There are list of things like how many allottees are there, when the permission was granted, so who are the other people and etc. These are relevant for the purpose of the IBC and for the IPs as well. But if it is not registered, then it is difficult to get the things. So I'll just briefly touch upon what are the informations which has to be given at the time of the registration. So when an IP is taking over the project in any form, they can look for these informations in the project registration thing. So what is those? The brief detail of the enterprises, including name, registered address, type of enterprises, a brief details of the project launched by him in the past 5 years, whether already completed, being developed, as the case may be, including the current status of the said projects, any delay in completion, details of the cases pending, details of the type of the lands and payments pending. Any authenticated copy of the approval and commencement certificate from the competent authority obtained in accordance with the laws, as the case may be applicable for the real estate projects mentioned in the application, where the project is proposed to be developed in phases. An authentic copy of the approval of the commencement certificate from the competent authority for each of such phases. The sanction plan, layout plan, specification of the proposed project or the phase thereof, and the whole project as sanctioned by the competent authority. So if you correlate this particular emphasis with the definition of the project, then when you are dealing with the project-wise insolvencies, then you can say simpliciter that the project is the one which was approved by the competent authority. If the competent authority has given a nomenclature of the project, then it will be project, and the 10% and the 100 numbers will be applicable to that thing. That's how it's going to work if it has ever come into question. The plan of the development works to be executed for proposed project, proposed facilities to be provided, including fire, lighting, drinking water, the location detail of the project with clear demarcation of the land dedicated for the project, performa of the allotment letter, agreement for sale, and the conveyance deed proposed to be signed with the allottees. The number and types of the carpet area of the apartment for the sale in the project, with the area of exclusive balcony and veranda area and exclusive open terrace area appurtenant with the apartment, if any. The number of area of the garages for the sale in the project. So there was a dispute regarding whether the price of the garage can be included or not. So that's why it's made clear here. The names and address of any real estate agent, the name and addresses of the contract architect or structural engineer, if any other person concerned with the development of the proposed project. So when you are making your list, seeking the details from the promoters, whether that project is registered or not, you can simply copy all these details from here and ask for the details. A declaration supported by the affidavit, which shall be signed by the promoter or any other person authorized by the promoter, stating that he is the legal title of the land which development is proposed. The land is free from encumbrance. The time period within which he undertakes to complete the project, that the 70% of the amount realized from the real estate project from the allottees from the time shall be deposited in a separate account to be maintained in a scheduled bank to cover the cost of the construction and the land cost, and shall be used only for that purpose. That's important for all the resolution plans. Like if somebody is an authorized representative, then he can make a suggestion that this kind of clauses should be included in the future resolution plan, how it is going to be implemented. When there is a clause for payment for further payment in the resolution plan. Provided that the promoter shall withdraw the amount from the separate account to cover the cost of the project in proportion to the percentage of the completion of the project. So that's principle of the proportionality is given in the itself. Provided also that the promoter shall get his accounts audited within 6 months after the end of every financial year by a chartered accountant in practice, and shall produce a statement of accounts duly certified and signed by such chartered accountant, and it shall be verified during the audit. So again and again, why we are these provisions are important, because as soon as the CIRP launched, all the RERA proceedings comes to a standstill. But RERA does not vanish away in its totality from that real estate project. Even during the construction phase or post approval of the resolution plan, or even in the liquidation phase, these provisions might come up. When the company is getting liquidated as a going concern, what could be the terms and condition? What could be the terms and condition of the promoter which is going to come in and take over the project? So this is it. And this 70% clause is very critical for most of the allottees. And this account has to be opened in a scheduled bank, and there is a procedure prescribed for that. The grant of registration. So there has to be registration, there has to be extension. There are several schemes in the state government which always postpones the deadline from one thing to another thing. And revocation of the registration. If there are many projects which are in the CIRP where the registration has been revoked, or it has not been revoked just because of the CIRP, and the people are enjoying that, okay, once the CIRP is over, we will take the registration and etc. So when it can be revoked, the promoter makes a default, violates any conditions, involved in any kind of unfair practices, false representations, etc., misleading advertisement. There are several conditions which are being imposed in the RERA Act. Just a second. We are not so far concerned with the real estate agents. I think I haven't come across any of the thing where the real estate agent has been implicated in the IBC proceeding in one way or another. But I'm happy to hear from any of you if any case such cases come across. So functions and duties of the promoter. A person who is taking over the project will become a promoter. A landowner is the promoter, and what is their responsibility has been given in chapter 3. Quarterly up-to-date list of the numbers and types of the apartments or closed as the case may be booked. So the booking detail has to be provided. Whereas approvals has been taken, has to be. So there is a quarterly reporting of almost everything in the it is one of the responsibilities of the promoter. All the details has to be provided on the website, which sometimes it is provided, sometimes not. But when an IP is taking over, they should provide all these details which are required to be promoted. And they are responsible for all the obligations and etc. So there are very detailed lists. Prominent among them is like they can't violate any law. They have to form a society, give it carpet area, etc. So I assume that all of you who have dealt with these projects are familiar with these things. The importance of these provisions are that, again, even for the sake of repeating, it applies during the CIRP and post CIRP. So if there is any doubt what should be a role of the IP, they can always refer back to these provisions. No deposit or advance to be taken by the promoter without first entering into an agreement for sale. So this is one of the response. In many cases, it has been done. Then adherence to the section plan and the project specification by the promoters. So you people have seen the demolition of the twin towers in the Noida. The people can challenge it. And ultimately, what could be the consequences? It has happened in the Kerala, it has happened in the Mumbai, like the court has passed the demolition orders. Obligation in case of a transfer of a third party, not relevant for our purpose, maybe or may not be. Transfer of title. This is important for some of the people. The promoter shall execute registered conveyance deed in the favor of the allottee along with the undivided proportionate title in the common area to an association of the allottees of the competent authority as the case may be, and hand over the physical possession of the plot, apartment building as the case may be to the allottees, and common area to the association of the allottees to the competent authority as the case may be in real estate project and any other title document pertinent within us. specified period as per the sanction plan as provided under the local laws. Provided that in absence of any local laws, conveyance deed in the favor of allottee or the association of allottee or the competent authority, as the case may be under this section, shall be carried out by the promoter within 3 months from the date of the issue of the occupancy certificate. After obtaining the occupancy certificate and handing over the physical possession to the allottee, in terms of the subsection, it shall be the responsibility of promoter to hand over the necessary document and plans, including common areas, to the association of the allottees or the competent authorities, as the case may be. Provided that in absence of any local laws, the promoter shall hand over the necessary documents, plans, so and so within a specified time. Many of the IPs are facing the issue where the home buyers or the allottees are asking for the possession and there is no completion certificate. So what should happen in those cases? Because in many of those cases, fit-out possessions have been given. The law says that the possession cannot be given till the time as occupancy certificate comes, because there is a non-compliances, the project in the insolvency, so the occupancy certificate has not come. This problem may be resolved in upcoming amendment in the IBC to say that the possession can be given during the CIRP proceedings. Be that as it may be, some of the IPs have taken the stand that they will not hand over the possession till the occupancy certificate has come. Some of the IPs have decided to give the fit-out possession to the people where the project is complete, but the occupancy certificate has not come. So this is something. Return of the amount and the compensation. That hardly comes into operation in the IBC companies, but that may be one of the questions. Right and duties of the allottees. So what are their rights? The allottees shall be entitled to obtain the information relating to the sanction plan, layout plan, along with the specification, stage-wise schedule, possession of the apartment, a refund of the amount, documents, agreement to sell. All of these have been given very categorically in this thing. Then there is a development authority, regulatory development authority. Basically, it is developing the market and regulating the things. Then these provisions are like regarding the composition of the authorities and etc. Advocacy and awareness function of the authorities, so they are market makers. Let's come to next chapter. So far, any questions? I see many of the esteemed people, I think they are getting.
Sir, I have got a question.
Thank you.
This is regarding fit-out possession, sir.
Right.
Now, fit-out possession has been considered, in one of our real estate insolvency cases. The COC in their meeting, they have said that RP should not give possession of fit-out possession of any of the flats because it is illegal. Because in case of fit-out possession, the liability still remains with the builder. So COC has categorically, passed a unanimous decision in one of their meetings that there should be no fit-out possession. It can be given only after receipt of OC.
Okay.
That is one observation. Second, my question was with reference to the complaints which are being lodged with RERA. Is there any provision that projects which are not registered with RERA will not enter in those complaints, or will they enter it?
The RERA and all complaints, whether it is registered or not. So they will decide whether they should have been registered or not also.
See, as far as registration is concerned, it is up to the promoter to get the project registered. but the poor home buyer will not be aware whether the project has been registered or not, because while booking the flat, he would not have checked those details, and he would have booked maybe 2, 3, 4, or 10 years back, for which he has not got the possession till date. And as a result of failure of the promoter to hand over the flat to him, he has approached the RERA. So my question is whether is he required to check whether the project is registered with RERA or not? And secondly, whether RERA will be in a position to entertain the complaint for the projects which have not been registered with RERA.
Okay. So I'll answer step by step.
Sure.
First, a person who is filing the complaint can always check on the website of the RERA whether that project is registered or not. 2, whether that person can file a complaint even if the project is not registered, the answer is yes. Even if the project is not registered, the complaint can be filed in the RERA, because the RERA says that it is the responsibility of the promoter to register. But if somebody flouts the norm, the RERA is empowered to penalize them. So there were 2 types of projects when this act came into force. One where the development was still going on, and another where the completion certificate was given. These matters were taken up when the complaints were filed. These matters were taken up into the RERA authority, then in the appellate authority. Now this position is largely settled, that a project which was not completed when the RERA came into force are required to be registered. Even if they are not registered, the complaint can be maintained against them. Now, another question which springs from you, there was an observation of the fit out position. So I think you should get a proper vetted advice whether the COC has the authority to decide or not. Because what is happening is, in some of the cases, the COC is of the majority of the financial institutions, and the allottees are less. Then there is always a conflict between the interest of the allottees and the financial institutions. So there are cases where the COC has passed the resolutions to give the fit out possession, and that has been given. So I think on that aspect, you have to double check from your advisors that what should be the course of action you can take. But be that as it may be, the 2 questions are, I think, the law has been fairly settled, irrespective what the promoter has done. If the project is not complete, he is supposed to be registered and the people can file a complaint. But all those complaints will come to a standstill as soon as the CIRP has started. This has been fairly settled. So the complaints cannot continue. That's so on an RP's job, there is hardly any implication unless there is an order. So in some of the cases, then order has come before the RP has taken out the charge, or IRP has taken out the charge, where is an order of the compensation and etc. So where there is an order of the compensation, it is the nature of the decree, and you have to take that amount as the amount of the claim.
Right, sir. That's clear. Yeah, that clears the questions. Thank you.
Thank you, Avinash, for the question.
Thank you, sir.
And it's very relevant. Any other questions, sir, from anyone else? I assume that everybody has understood everything, but be that as it may be, the question really helped me to develop the argument. So there is an appellate tribunal. It's functioning, orders are given, but in real estate project, because of section 14, there is nothing happening in all these cases. And in the resolution plan, they are modifying it in such a manner that till the terms and conditions that there will be no further complaints. So if any of you have been drafting a resolution plan for the real estate companies, then you can take into account all these aspects, that these are the obligations under the RERA and how the proposed resolution application meets out these things, meets out these challenges which has been given in the RERA. So there is a term of chairperson and etc. Offenses and penalties. Penalties are much severe here compared to Consumer Protection Act. So for just taken if a punishment for non-registration, that was the last question. If any promoter contravenes the provision of Section 3, he shall be liable to a penalty which may extend up to 10% of the estimated cost of the real estate project as determined by the authority. So non-registration is a penal offense and this can be entertained under the RERA authority. If any promoter does not comply with the orders, decisions, then again the penalty is further 10% of the estimated cost of the real estate project. So we have seen that in the Consumer Protection Act, there was hardly any implication, but here the implications are very serious. And this 10% penalty concept also exists in the CCI, Competition Commission Act. This also exists here. So if somebody has taken the risk, then it's something very significant. Penalty for contravention of Section 4, I think it's 5%. If any promoter provides false information or contravenes the provision of Section 4, he shall be liable to penalty up to 5% of the estimated cost of the real estate project. Misleading advertisement. There is hardly any implication here, it is significant. And for all other provisions, it is 5%. So, and there is a concept of day-by-day default as well. I think that the Section 9, if any real estate agent fail to comply, this is for the real estate agent. So most of the things, the penalties are more serious in the RERA. So when the people are approaching to the different jurisdictions, they take into consideration what are the chances if they succeed. So this is the difference between the Consumer Protection Act and the RERA, that in Consumer Protection Act, the rights given are larger, but the effectiveness, ultimately enforcement, there are not too much because it's an omnibus legislation which encompasses all kinds of product and services. Since in the real estate sector, it's a industry specific legislation, so penalty has been designed to keep in the mind the stake of the stakeholders, and therefore they are fairly large enough. And they want to make sure that they complies with the law, so it's there. More or less, I think we have covered both these acts. And now I would like to ask again, like if any of you have any other questions, which otherwise I'll stop share. These are the two documents, and all of you have been like so far wonderful audience. There are very few questions, but it will really help me if somebody, Deepak ji is speaking something.
Yeah, you have beautifully covered both the acts and explained well. Thank you so much, sir. Yeah.
Thank you for the appreciation.
Yeah.
Sometimes really, like I'm not sure, but sometimes it really feels like I'm happy that at least today there are many faces. One of those sessions, I was the only face, and like after half an hour, I felt heartless to even to speak, like whether anybody is there or not. So thank you very much for keeping your cameras on. The more
no, people are there. People are there. You need not feel alone. People are there. People are listening to you, and you have been very clear in your concepts.
So, okay, so there are few questions in the chat box. I haven't noticed them, so I'll just answer them. So the first question is user number so and so. So I don't know how what is the name, but it says the question about the standard project where license to develop the land is subject to payment of EDC and IDC by the builder within the stipulated time. Builder failed to pay, still the DTPC which gives the license, instead of cancelling the license, has the claim when what should be the treatment of the claim. So this is a typical Noida Gurgaon problem where the IBC and external and IDC has not been paid. These are the government dues, and once they have filed the claims, means like they have decided to become a creditor and not to enforce or to cancel the license. So the question has to be looked from the angle of the stage of the CIRP. If pre-CIRP it has not been cancelled, then during the CIRP it cannot be cancelled. If during the CIRP it cannot be cancelled, then the authority has only one remedy, is to file its claim. What will happen to those claims will be decided in two ways. Either there will be a resolution or there will be a liquidation. In case there is a resolution, the successful resolution applicant will decide that what will happen to these EDC and IDC charges. There are two aspects of decision making. The first aspect is yes, I will elaborate the reverse CIRP as well. So the first aspect of the EDC and IDC is that the people feel that we can write them off because they are not financially. Be that as it may be, some promoters still decide to pay because unless they pay EDC and IDC, it's very difficult to get the project restarted and make the allotment and the money. So there are both kinds of applicants. Some of the applicants are paying and some of the applicants are not paying. But as an IP, the consequences is that much of not relevance because it's the resolution applicant who decides. So if you are for the resolution applicant, you have to take a commercial call to what would be the impact and how far you can execute by fighting the authorities, because it's impossible to get the other letters and approval unless you pay them. Now, if the company has gone into liquidation, obviously it can be cancelled and the future applicant will see what happens to them. So it depends upon the stage, and that is, I think, was the question, and I tried to answer it. If there is any follow-on question, please ask. I don't know the name, so I can't make sure who has asked this question. Is that answers the question? Okay, thank you. Now there is another question. Acha, thanks Tanuji. So thanks for saying that it clarifies your answer. It helps me a lot. Now the next question, can you please elaborate more on the reverse CIRP? Reverse CIRP is a nomenclature which was developed by NCLAT in one of those cases. So far, I think there are only 4 and 5 cases. It's actually not reverse, but they said it's a reverse. In this case, what happens is typically either promoter or the home buyers gives a proposal to say that we do not want to have any third party in the resolution process, and we will ourselves will take upon the company and complete the project. So a creditor or a group of the creditors or the shareholders themselves take upon the responsibility to make the company up and going. What are the contours are not specified. It's going case by case basis. So the first case was decided, it was a comparatively straightforward case for the NCLAT, because there the promoter said that I will complete the project within 4 months or something. So NCLAT says that why to send it into the liquidation when everyone is getting the home, nobody is supposed to pay extra. But with that judgment opened a floodgate where the people have started saying that we want the project to be complete. So in those cases, the various home buyers or the group of allottees are filing the application. And there is no straitjacket formula where it can be put. So the process is straightforward in the sense that you need not bother about the eligibility criteria, etc. when drafting your proposal for this reverse CIRP. It has to go through the COC, and it is ultimately the discretion of the NCLT. Rest of the things are completely unclear. And I think in future legislations, they will be made clear. But as of today, there is no guidance where you can say that that has to be a resolution plan only by these stakeholders. These are the normal parameters, and only these people in the can do it. If they don't do it, it will fail. There is no such criteria specified. So the ground is wide open. Anybody can make an application, and those applications will be considered depending upon the merits and the resolution plan and the support they gather from the members, because ultimately it's a democracy within the institution. This is my answer to it. But if there is any follow-on question, please ask Pratibha ji. Any follow-on question, Pratibha ji?
No, sir. Thank you so much for elaborating on the topic.
Thank you. Thanks for asking the question. Yes, sir. Any other question? I'll just check the chat box if there is anything else. In between, all of you can ask. Yes, there is a question from Bishwa Ranjan Chatterjee ji. Does it mean that if I buy a shop, then I am not able to take help of the Consumer Protection Act? So, Bishwa Ranjan ji, answer is that if you buy a shop which is for your self-occupation, you can definitely invoke Consumer Protection Act. You cannot invoke Consumer Protection Act if you have bought 10 shops and say that I will sell it to somebody else and I will buy 10 more. So if it is stock in trade, you are prohibited. Otherwise, you can go for the Consumer Protection Act. 1, 2, 3 shops, there is an order from NCDRC to say that you are a consumer. Is that answers your question, Vishwaranjan ji? Okay. I think he might have left, or his mic is not open. Okay, so there is another question. In redevelopment of the cooperative society, whether society is a promoter and member of the society is allotee. Yes, they are promoters. Members of the society are allotee. Yes, they are allotees. You can see the definitions of the promoter and the allotee. So both are covered in the redevelopment. This is typically a Bombay question, to my understanding, because the redevelopment works, like maximum amount of the redevelopment works takes place in Mumbai because of the tradable development rights. Purnima ji, does this answers your question? Thank you. Thanks for understanding. Let me check from the beginning if there is any other question. I think I have checked. Thanks for your clear reply to my question. Okay, no issues, sir. Thanks for putting it in the chat box, Visuranjan Chatterjee ji. I think I have answered so far all the questions in the chat box. If there is anything, please put in the chat box. Or you can just switch on your mic. You can ask anything.
Sir, I would like to clarify one thing here. At the beginning of your session, you said that to put the cameras on. Of course, this is not very relevant, but I would like to mention here that this webinar has been kept on a working day, and for a person who is located in Mumbai, at 9:30 he will be at home. By 10 o'clock he starts. He will commute for 1.5 hours in his car. So that will be the second venue, and third venue when he reaches the office. So there will be 3 venues as far as he is concerned. That is why the cameras were not put on. We may be excused for that. That was the only submission.
You are really genuine. But today I'm happy that there are many people. But what happens that, like, I was just having an incident, like I was giving one of these webinars where, except me, there was all the cameras were shut off. So there was a blank screen with the name of like 30 people. So you feel the like whom you are speaking to.
I can understand that. I can understand, but I just wanted to place the reality in front of you.
Yeah, that's true. That's true. But at
That's
least
the beauty of the webinar, sir.
Pardon,
Yes.
sir?
The beauty of the webinar. You can speak without there no one is there, but their name is there.
So thank you all for attending the session.
Thank you, sir. Thank you so much.
And thanks for all the wonderful questions. And
Thank you so much, sir, for taking the session. It was very interactive and helpful. Thank you very much. And thank you to the participants also. So we will now have a break for lunch. So the next session will start at 1:30.
Thank you, madam.
Thank you, sir.
Thank you.
भाई साहब नमस्कार।
Yes, sir. Any issue?
सुशील जी नमस्कार।
नमस्कार भाई साहब नमस्कार।
क्या हाल चाल है? यहाँ तो लंच टाइम है, 1:30 बजे होगा शुरू।
हाँ मेरे को लगा शायद चालू होने वाला है, तभी मैंने भी ऑन किया।
1:30 बजे होगा, 1:30 बजे सर।
1:30
मैं
बजे।
तो बैठा सुबह से यहाँ पे देख रहा था, काम कर रहा था मैं। मैंने कहा 1:30 बजे होगा फिर क्या है।
ठीक है।
और क्या हाल चाल है आपके?
बस ठीक है।
कैसे हैं?
बढ़िया है।
क्या है, बड़े दिन हो गए आपको।